So our first hearing is on SB 27FN relative to dwellings over water. The prime sponsor, Senator Lang, could not be with us today, so the Senate Majority Caucus Director, Tricia Melillo, did I say that right? Close enough, is going to present the bill for him.
That's
Thank
close
you.
enough. I have to spell that all the time for people. Good morning, Mr. Chair and committee members. I am Tricia Melillo, Senate Majority Caucus Director for Senator Lang this morning. He's in Ways and Means right now. Senate Bill 27 is a simple bill, and there are people behind me that will answer questions if you have questions. It simply would specify how improvements can be made to dwellings over water, bring them in alignment with the state building code. So it specifies different things on that. And Attorney Cronin is here. He can answer any questions that you may have on the details. That's all.
Any questions for the speaker? Representative Darby.
Sure.
Thank you, Mr. Chair. Thank you for taking my question. I know you don't want questions, but I'm just wondering if Senator Lang is bringing this on behalf of a constituent or a specific case he's trying to address.
Yeah, I am not sure about that. Attorney Cronin might have that answer.
Thank you.
Thank you. Okay,
No
thank
more
you.
questions. Thank you
you.
very much.
Thank you.
Appreciate you being here. In support of the bill, John Cronin.
Good afternoon, good morning, I should say, Mr. Chair, members of the committee. Thank you for allowing me to come here. Oh, there you go. Courthouse red light screen, getting educated here. Once again, Mr. Chair, members of the committee, thank you for allowing me to come here and speak this morning on this bill. And I thank the sponsors for bringing it forward in the Senate where it passed on the consent calendar. I've been practicing mainly land use law for close to 40 years here in New Hampshire. I've worked for most of that time with the DES, and I would say I have a positive relationship with them. Appreciate the work they do and the protections they provide to our wetlands and our waterways and lakes and so forth. This bill came about as a result of a case, but it has widespread impact to a limited number of folks that have older homes that were built under existing law that are fronting on the waters of New Hampshire. Lakewood at Pisaki is where I've had a number of these cases due to its size, but there's other water bodies that have the same circumstance. It went through a process with the DES regarding some what we call exterior improvements, and I have some photographs. A home that was built in the 50s. The person that built it at the time built it close to the water where you couldn't build it today, did some dredging to create a little boathouse under the back porch, the back of the house, if you will. And it existed there for a long time, went into disrepair, foreclosure, terrible state. Mr. and Mrs. Newcomb, who are with us today, purchased it and started to rehabilitate it. Did all the right things, went to the town, hired an experienced builder, went to the town hall and got some permits. Were asked to make some modifications to it. There was a question of whether it needed state approval. The contractor testified at the DES that he went to the DES and was told that it didn't need state permits because of its existing structure and whatever. The Newcombs, not being expert in it, were happy to proceed and go forward. They built it. Everyone in the neighborhood seemed to be very pleased with the exception of one neighbor who reported it to DES. DES came out and looked at it and say technically under the existing law, it's a violation. And under the existing statute, we don't have power to waive it, even though the testimony was that what was done has no negative impact on the water, no negative impact on plant species, no negative impact on fish, and is an all-around positive improvement for people. Supreme Court Judge Broderick, one time when I was arguing at the Supreme Court, said when you see a law that doesn't make sense, it may not be the best place to argue it in the Supreme Court. You should look to the legislature to amend that bill. Former Senator Kavanaugh is from Manchester, where I am, knew him well. He helped me with this process. Senator Lang and the co-sponsor, Sanborn and Meredith, Sanborn and Wolfboro, have interest in the lake as well. And that was the origin of the bill. I think we initiated it with the help of Kevin Kavanagh and Senator Lang to bring it forward. But it impacts a lot of folks around the water. It's been amended. It came, as I said, through the Senate on consent after some amendment, which we have no exception to. The DES wanted a modification to say that if there was an improvement being done, that there'd be no new structures in the water, which makes perfect sense. And one of the redesigns here that was required by the Wolfboro building inspector was to take the supports. And I'm just going to hold this picture up for you. I have a number of copies. I wasn't expecting a committee this large, but you can see the improved home and that porch out in the back. It goes across, and you see the supports for it are cantilevered back into the house. I have a photo, not such a great photo, of the older house, which had little jealousy balconies over the back area. Initially, it was intended to provide easy access for one of the parents of the Newcombs who was wheelchair bound. Unfortunately, that person passed away before it was completed. But we are looking to give waiver power, not in every circumstances, but in the appropriate circumstances, when the DES looks at a situation and says it doesn't make any sense for the state and the taxpayers to spend thousands of dollars, perhaps over $100,000 in this instance, to order someone to tear down an improvement that is generally well received, has no negative impact to the public health, safety, and welfare, and adds to the tax base. We understand that this is still going to be a case-by-case process, and the DES will have a say and a role, but this will give them the flexibility in situations like this to say, hey, there's no problem here, it's an improvement, we think you should be allowed to do it. So that's what we're hoping to accomplish in the bill. And we appreciate all the people that have contributed to it, including the DES, who have, I believe, made positive recommendations. So I will circulate these photographs.
Didn't give you one?
I believe that photograph at least will give you context to the type of the things that would be permitted. As you can see that shoreline there, it's pretty apparent that whoever built this house in the 50s, when there was no laws prohibiting it, went and created this garage door to bring a small boat in. And what was improved is that staircase, as you see in the back, with the landing.
Water.
So I hope that gives you context. I'm happy to take any questions if that photograph has triggered any.
Representative Gould.
Thank you for taking my question. This picture, it looks as if only the deck is over the water, and the bill says over water, so I'm a little confused about
Yes,
that.
the deck is the only part that's over the water, and that was the improvement that was done. It's partially over water, as you can see. It's probably not the best angle from above, but you can see to the left is the picture you're looking at. The Newcomb's property sticks out quite a bit, and then you can see to the right how it curls back. It appears to us that someone, when they built this house, did what they needed to do to excavate to build a foundation. But the only thing that's being added there was that deck and stairs.
May I have a
Follow-up.
follow up? Yes, thank you. Is the house over the water at all here? I can't tell.
If you open that garage door and went in, there's a small, I call it a boathouse. So you drive in, probably an 18-foot boat, 16,
Okay.
18-foot boat, you could get in there. Not a big one by any means, but that's, the water flows through, which begs a whole different question that's probably not before not connected to this bill, but who owns the water underneath the house? Is that public water or is it private water? And with the new DES regs where new boathouses required to be dug into your own land, I think that's an issue that somebody will have to wrestle with sometime in the future.
Okay, thank you.
Representative Nab?
Thank you, Mr. Chair. Thank you for being here and taking my question. The bill references living space. Is that something that's defined anywhere else in statute, or how do you look at what living space is defined as?
I think there's different references to it if it's specifically defined. I can't say off the top of my head. I think what the DES wanted and the way we wanted to tailor it so it was narrow, you don't want someone to come in, right, and take one of these homes that's pre-existing and add a couple of bedrooms to it. So that was really the juncture of that. So when they talk, I think another addition that's in the bold in the bill there talks about the access and egress ways being something that would be permitted. And I think this is what this bill does and wouldn't give anyone authority to create any living space.
Representative Donnelly?
Do you know, thank you for taking my question. Do you know how many homes do you think this expansion, this bill will expand to? How many additional homes will be able to take advantage of this legislation?
That's a good question and one that was asked by the Senate. Having the good fortune to have a place in Guilford that you see a number of them, I can't estimate it. How many of those would want to do any improvements such as this for better access or better safety, I can't say. But I think in comparison to the total number of properties in the state, it's a very small number.
Representative Darby?
Thank you, Mr. Chair. Thank you for taking my question. It appears that the language of this bill would require DES to become familiar with all local building codes because that would be one of the conditions that they would be allowed to sort of supersede or provide the permitting. Are you aware of other cases, other laws, RSAs, based on your experience as a lawyer, where DES is responsible for being familiar with local building codes?
I don't think they have to be expert on it because in all of these DES applications, they're already inquisition as to what local permits may be needed. And when you send your plan sets up for anything, say you're within the 50-foot setback and not over water, there's questions on the application and requirement on the plans relative to local permits. So I think the DES, and I know Ms. Forst is here, they're generally looking at information that's submitted with applications that's confirmed by the local authorities, whether it's a local building department or someone that would issue a permit there.
Follow up?
Thank you again, Mr. Chair. Thank you for that answer. One other question I have is you mentioned, it's debatable who owns the water underneath the house. I get that. But who do you think owns, from your perspective, who owns the water underneath the new deck?
It would be an interesting question. In this case, my position, looking at the title, would be that area underneath that deck is owned by the Newcombs. I know the DES takes a different position because, like a lot of deeds in the 50s, not as precise as you might want them to be. And I get the riparian rights with the ebb and flow of the lake, not like the ocean with tides, but it's generally well defined. So that's an interesting question. I think whenever it's going to be something that this bill relates to over water, the assumption it would be over the public water, right? I mean, that would be the assumption.
Thank you.
Representative Dupont?
Thank you. Did you say you had pictures of the before?
Yeah, it's not great, but I'm happy to circulate it.
Representative Baldwin? Oh, that is- that's- I don't know, he gave it back. He didn't want it.
Yeah, just for context, I know that's a little difficult to read. That's the same back of the house that you see in the gray picture. There's jealousy balconies and sliders. Each one of those windows is a slider. Why they put a slider there, I don't know, but they did. And they had jealousy balconies there, presumably for
That seems
protection.
like that.
That went out a short distance, really not balconies you could sit on or do anything on. It was more protection for the sliders. So that was the before.
Well, I have a question for you. Without stealing the testimony of Darlene Forst, she did present to us a letter, and I know some of the members of the committee are concerned. In her letter, she states, if decks are not considered living space, then this bill would allow unlimited expansion of decks on structures subject to RSA 482A26. Do you agree with that or not?
I haven't seen that letter, but would you read it again for me so I can try and absorb it?
I'll read the sentence before. The bill will allow expansion of structures so long as the footprint and the area of living space are not increased. If decks are not considered living space, then the bill would allow unlimited expansion of decks on structures.
I don't think it's limited. The DES would still have to approve it. And they could look at it and say, this is ridiculous. You're trying to put a major deck on the back of a building. And they could deny the waiver, which they have a right to do. So I don't see that. Again, I haven't just got a copy of the letter now. I haven't digested it. And if there's language that prevents that, there's nothing here that's being sought after to create anything more than access.
So I'm going to ask myself a follow-up and say it's okay. So my follow-up is this. I'm an attorney too, and I'm also a zoning attorney. So I read the bill, and when I read it, it appeared to say that the footprint can't be expanded. So I'm confused. If the footprint includes the existing deck, why would you even be able to expand the deck under this bill? Because you're expanding the footprint. Do you have a definition of footprint, or do you agree with my analysis?
The footprint is in my experience, is the foundation, the perimeter of the foundation, the four corners of it. And I think that's pretty well interpreted at DES, where you look at it and say, this is the footprint of the building. So if you were to go up on that or to go out, you would be outside of the footprint.
Representative Nab.
I guess I don't know if this is a question, but thank you for taking my question. I don't think DES can say, oh, this is ridiculous. That's not really a legal term or a way to respond to a building permit. So I am concerned about this issue of the deck. If the footprint is only the four corners, it does feel like the deck could be expanded. On the other hand, this bill says that you can't put in new pilings, right? Like you can't put in so a deck that expanded could only be as big as a deck that could be cantilevered in, right?
That's correct. That's a good point.
Couldn't add new footings
And if you look
for a deck.
Right. If you look at the picture there, that is cantilevered.
That's what they did. And you're not an engineer, so sorry.
No.
Follow up. So I guess you can't tell me how far a deck could go out with, but I am sort of curious about how big a deck could get that wouldn't require new footings.
Well, and unless you're using steel, not very far.
Sorry, that was a little random.
Yeah.
Anyone else?
Thank you for taking my question. Looking at this picture here, All right, if I own this home, from one corner is land to the other corner of the land, I could build something across that. And then I could cantilever my deck another 4 feet, 3 feet over that. So if I pass this law, I could build a deck that would actually come out like another 12 feet legally from the house.
I don't believe that you
If
could.
I put a footing from the right hand of the corner of the land to the left hand corner of the land, I can build something across the water from land to land. Because
Only,
we're not talking footprint now, because you're saying the deck is in a footprint.
only if the DES permits it.
Yeah.
Right. So you can't do it unless the DES says yes. So the concern about this are people running wild and taking the language of the bill and doing things that are not intended. There's an automatic check in this. Anything that you do within that 50-foot of the water, you have to go to DES and get a permit for it. The real issue here is members of the Wetland Committee came up to me and said, we wish we had the waiver power for this, for buildings over water, like we have for other sections of our law, which we don't have. And Mr. Chair, as an attorney, I don't know if you had a chance to look at that, but it is kind of unusual in the DES statutes and regulations. They have broad waiver power, arguably power for this type of situation, but they claim that they do not because the legislature hasn't given it to them. So you still have the folks at DES. If Representative DuPont came in and said, I want to go 12 feet out over the water for the length of the house, they would say no. And you'd have to have your expert testimony that no impact to the fishermen, no impact to the wetland, no impact to the water, no impact to the plant life, et cetera. So you couldn't just do it.
I'm going to go with Representative Sargent. He hasn't spoken yet.
Thank you, Mr. Chair, and thank you for taking my question. I just pulled up the case appeal of Robert Newcomb, decided by the Supreme Court of New Hampshire, August 5th, 2022. Is that the case you're referring to?
That's the case. It's part of it, yeah.
And they found that the construction of this deck was for regular maintenance.
Yes.
So I think what was their main finding?
Their main finding was that it had to go back, which it did do. It went back. And I agree with you. I think the direction, if you read it, was to kind of the DES that this was a maintenance which is already covered. But we didn't have a hearing in that appeal that you're looking at. There was no testimony. There was no trial. It was a summary disposition. And the Supreme Court said you should give these folks their day in court, if you will, so you can bring Dr. Rosine, the wetland expert, in to testify, the building inspector to come in and testify, and all those people did. And it was after that case that the DES said, well, we still think it's a violation, and sorry, we don't have the waiver power to do anything about it. So ultimately, if the Supreme Court, which that is on appeal, to Supreme Court. If the Supreme Court doesn't do something, or this bill doesn't get passed, the Newcombs here are looking at tearing down a perfectly good structure, which they did in good faith, with no ill will, hired the right people, guy that does a lot of work at the lake, took all the right steps. And that seems shame, number one, and not grounded in common sense. And no negative impact from this, the health, safety, and welfare of the community.
Follow up.
But and I get that this is not a published, well, I'm not actually sure what this is, but this opinion. But if the Supreme Court just reiterates its first holding that this was allowed under the statute, is my 2-second read of this case, there's no need for this amendment, right?
Not really, because it's not just this property, right? There's others that are going to be in the same predicament. So it's not a one-person bill, if you will. But we did go back after that case and said, hey, DES, we got a decision here that this is maintenance. Can we put this to rest? Even though we didn't do anything wrong, we're willing to pay a fine, but we want to bring this to an end. And regrettably, they said, no, we have to go through the hearings process, which we've done. So I wish it were different, but it isn't. So unless there's some change or bill, we're looking at an order to tear down that improvement.
Representative Taylor, you haven't spoken.
Thank you, Mr. Chairman. Thank you for being here today. Do you think this piece of legislation should be expanded to cover bodies of water under 10 acres and streams, rivers, brooks?
I couldn't comment on that. I haven't done the homework on it. And my universe of things that I know from being on the lakes for a long time is there are a number of these properties that are around. Some of them are not in great shape. You'd like to see them be improved and cleaned up somewhat. As far as the lakes and streams, and make no mistake, I wouldn't want to do anything that harms any of our waterways, whether they're lakes, the ocean, the streams. And I think the reason for this bill to have the waiver piece is that when you go and ask for permission to do it, whether at the lake, whether on a stream or a body of water under 10 acres, I think an applicant should demonstrate that there is no negative impact. Because if you're trying to do something and say, hey, there's a negative impact to the water for this improvement, whether it's a deck or anything else, you probably shouldn't be allowed to do that. You definitely shouldn't be allowed to do that. If there's a negative impact to the plant life and fish, shouldn't be allowed to do that. So I think you got to do more than just have the bill to get to do something.
Representative Nab, then Representative Darby. And remember, we do have Darlene Forst that's going to speak also.
Thank you for taking my question. I just want to clarify, there's a control from DES, but presumably DES operates just like a planning board. They can't say, we don't like this project just because they don't like this project. Like, they have to be able to point to regulations. Is that not true?
I'm thinking of how to answer that. As far as a planning board, they have pretty broad discretion on what they do, but they have to follow their regulations.
Yeah.
Same with DES. I will just say, as much as I appreciate what DES does, and I would qualify my relationship, even though we've had our tussles, as positive and respectful, I think it's a very difficult organization to deal with.
Representative Darby.
Thank you.
Thank you, Mr. Chair. Thank you again for taking my question. This second picture came after my earlier question, so I apologize for a second question. Was this the structure that they built, that they bought?
Yes.
Okay, so it didn't have a deck over the water when
It
they
did
bought
not.
it. Thank you.
It had the jealousy balconies, which presumably are over water. And if you take the square feet of those and apply it, the deck is a little bit bigger, but not all that much. So those decks were removed as well as the sliders.
One more question.
Thank you for taking my question.
Thank you.
Was that deck in the plans submitted to the town originally? In the DES?
When the
Did they
new-
know this was coming, this deck? Did
Yeah,
they see that?
Oh, yeah. And the
And they approved it?
the plans to the town, you're
Yeah, the
saying.
plans for that deck
the
extending
bill-
over the water was submitted and they approved it.
The building inspector approved it. He's the one that recommended
Yeah.
that the footings
Okay.
be cantilevered rather than
Right.
into the
Yep.
water. So
Okay.
he, not only did he approve it, he came out and inspected it
Yeah.
during construction, and
Yep.
nobody
Okay.
stopped it.
That's good. Thank you.
Well, I don't see any new lights, so thank you for your
Thank you all
testimony.
for the good questions. Appreciate it.
And from DES, Darlene Forst. I believe you should all have her letter of testimony.
Good morning. My name is Darlene Forst. I am the current Wetlands Bureau Administrator at the New Hampshire Department of Environmental Services. Prior to being Wetlands Bureau Administrator from 1997 until 2000, I was a shoreline specialist within the Wetlands Bureau, and from 2000 until December of 2021, I was the shoreline section supervisor, which probably makes me the expert on some of these subjects. I will not read to you the department's letter of testimony. It seems many of you have already read it, which we greatly appreciate you taking the time to do so. Will make a couple of points on behalf of the department. We are somewhat surprised to be here today. We were under the impression that this bill was sent to interim study in the Senate because we very much want an opportunity to discuss the underlying intent of the legislature for 482A26. And we have serious concerns about what these changes would require us to do, what the legislature's intent for us to do would be, and what the impact of this law across the state would be. We do not feel that this language is clear in any way. We also have concerns about the fact that this case that is mentioned is still being adjudicated. It is not closed. This does not seem to be the place to re-adjudicate or have a sidebar adjudication of a very specific case. And I would say that because it is a case that is still ongoing and is still active, it is not fully closed out, it has not run the full course of its appeals, where DES, while I am here to represent DES attorney is not here, although the other party's case has, the other party's attorney has just testified. I would ask and appreciate that I may be somewhat limited to what I can answer on the specific case in question. But as the technical expert on this thing, on this issue, I'm certainly happy to address any questions of fact, policy, how DES views specific things. The gentleman to my left, Representative Taylor, asked a question about, I believe he asked about dug-in basins, property lines. Someone had asked that question. What happens when you dig a basin? Or actually your question, sir, was, would you apply this law to properties where it was less than 10 acres in size? The surface water was less than 10 acres in size. And I will give you a wee bit of history on this. A property, a great pond in New Hampshire, a pond greater than 10 acres in size, they are public waters, but the bed of that water is held in trust on behalf of the people of the state of New Hampshire. We do not own it per se. It is not something that we have a deed for. The legislature is the trustee of the people. You pass laws on how to regulate that. We at DES and the executive branch attempt to implement those laws. There are limits to even what the legislature can do in those areas. The reason that this law exists is because when you cross the natural mean high water line of a pond greater than 10 acres in size, you cross a property line. You are no longer on private lands. You are within what is essentially the commons. You are within the land and the possession of the people, of which we are the trustee. So would we apply this to a pond less than 10 acres? The answer would be probably unwise, because those beds of a pond less than 10 acres are privately held. It is not a property rights issue. It is purely an environmental issue. When this law was passed, its first existence in any form was roughly 1967. It was July of 1967. And this is an issue of what is a private use, an appropriate private use of something which belongs to the people of the state of New Hampshire. And with regard to the questions about DES and whether or not we have waivers, while I did not deliver the testimony to the Senate, I had a commitment that day. Having been involved in enough internal conversations and knowing my supervisors within the department, I can assure you that we are in no hurry. No one within the Department of Environmental Services wetlands community would ask for waiver authority on this. We are the Department of Environmental Services. This is a policy decision that goes well beyond the environmental realm. It is about appropriate use for a private takings of public trust. So since it was attributed that it might be someone from the wetlands community that very much wanted waiver authority, I don't know who that person is. I'm not saying that Mr. Cronin was not being factual. I am simply stating that whoever that person in the wetlands community was, they are not a member of the Department of Environmental Services, because this is outside of our area of expertise. One of our primary concerns in this area is we are not enforcers of state and local zoning. We don't have that capacity. This would cause us to now need to get in and look at zoning code. And it wouldn't be local zoning code, we don't think. Because there is also not legislative history, there is court precedent, there is case law with regard to the ability to regulate structures over great ponds. Because the legislature, because of the nature of great ponds, there is no adverse possession against the public trust. You can't be there for 20 years and say it's mine. It just doesn't work that way. There is very specific case law that speaks to the state having reserved to itself the right to regulate structures over public waters. For this reason, towns cannot regulate docks. They do tax them, I get that. That is not what the court case said, but they cannot regulate their size and they cannot regulate their use. We do not know if that case law also would apply to residential structures. There is a legal hole that we honestly do not know the answer to. If a town chose to say, this does not meet local zoning, and an owner said, well, guess what? You have no say here. This is over public waters. We don't actually know what the answer to that is. So that is the reason. Those issues of legislative intent, ultimately, this isn't an environmental issue. This is what should the private right over the public trust be? Those are the legislature's decisions. Once you've made them, hopefully with clear guidance to us, we will implement them. But the case law is very clear that it shouldn't be invested, like the waiver authority, the choice of what's appropriate when it comes to balancing uses if they're not environmental, it does not fit us well. And we do not feel that there is enough guidance in this to tell us how we would make a decision to waive something. When is a deck appropriate? When is it not appropriate? This is why we request interim study. We actually very much look forward to having good legislative guidance on this, because even this issue aside, this comes up fairly common. There are several of these structures on Winnipesaukee. There are far more of these structures on Lake Sunapee. It's not so much the size of the lake, it's the nature of the community that surrounded that lake that probably led to their formation. But these are not uncommon questions, and there are several structures that this would impact. So with that, as I said, please, we would love to have your input, but we don't believe that we can fully advise as to what all the circumstances to be considered would be in this forum, and the department requests interim study with regard to this issue. I'm happy to take whatever questions you may have.
Representative Sargent.
Thank you, Mr. Chair, and thank you for taking my question. I was glad to hear that you brought up Lake Sunapee. I represent Newbury and New London, and I spoke with the Lake Sunapee Protective Association yesterday on this particular bill, and on the DES letter and recommendation for study. They support that move, so I support that. And I had spoke also with a constituent who has one of these houses. And I just have a generic question for you, unrelated to this particular amendment. If one of these houses is destroyed by fire or ice or hurricane or whatever, are they allowed to reconstruct it?
Under current law, the answer is yes.
Okay, thank you.
Representative Bucco.
Thank you, Mr. Chairman. So I'm looking at this photograph and I see water running underneath the building, all in a living space. Isn't that a life safety issue? Where the underneath of the house, the living space is going to end up being rotted away from being wet all the time.
Could you elaborate on a life safety issue as an immediate harm, or?
Yeah. What happens if the floor gets all rotted over a number of years and somebody steps on it and falls through the thing?
The law specifically allows for the maintenance of these structures, so maintenance in kind or even maintenance with a foundational improvement. So if that was wood now and they chose a steel option, current law in RSA 42A26 does not prohibit them to maintain the structure in kind or even make structural material changes for better longevity.
Does not.
It does not prohibit that now.
Thank you.
Representative Nab.
Thank you, Mr. Chair. Thank you for being here. If we took this to interim study, what are the steps you would recommend or the information that you think we need to gather? Or is it just clarifying this bill further?
There are certain terms that should be defined. There are places in the law as it exists now where the language seems inconsistent with regard to reconstruction and expansion or conversion of commercial use. There is the question of what does the legislature believe is appropriate use of these, and giving us better, if there is to be a waiver, what would the circumstances be if not environmental? As for history, I think it would probably, we would be happy to provide what history we can as to its original context, what it did when it was originally brought into existence, why when it changed, and why it changed.
Representative Bridle.
Thank you, Mr. Chair. Thank you for taking my question. I'm a little bit of a novice at this. I'm trying to get a general question. One of the representatives have asked if there was a fire or disaster, they would be allowed to rebuild. With the current state of the dams in this country, if a dam were to catastrophically fail and the water level of the lake were to recede or drop, and if you don't know the answer, that's fine too. What would happen then? Say the water in this picture were to drop by like 10 feet and the shoreline would change. At that point, would the homeowner be permitted to, say, close that off and rebuild as though that water was never there in the first place?
They would.
I know it's a real specific question, so I apologize.
No, but welcome to my life. So yes, I know how to answer this. So there are many different ways that we have that our water bodies are supported. There are some which have their natural impoundment. There is a natural restriction which maintains water level. There are some where they are a dam. If it was a river that was dammed and that dam raised the water level, if the state of New Hampshire purchased the land before the dam was built so that we actually own the flooded land in fee, then we own it in fee and we have a deed for it. So that would not change anything. If it was a natural water body, and this is true for many of our lakes, Sunapee, Winnipesaukee, and Ossipee, during the Industrial Revolution, they excavated the natural impoundments and then built dams in order to maintain the water level, but increase the head draw potential in order to ensure that they had good power for their mills throughout the year. Which is, for Winnipesaukee, for instance, if you're familiar with it, the dam is at the lower end of Paugus Bay. The original restriction was the weirs. They built the dam at the end of Paugus and then dredged the weirs so that all of Winnipesaukee could be dredged. If you really wanted to get down into this during interim study committee, I can give you the history of that as well. If the natural mean high water before the dam was built, that elevation is still the public trust. That will not change just because the dam fails. We might even actually, under some 1927 law, be required to rebuild it. That would be an interesting point of discussion. It does not, the law is explicit, it is the natural mean high water. If we chose historically to manipulate that, it does not, and I think this goes to what I said earlier about the historic case law and the limits of legislative action. You cannot take from the people what we absorbed from King George when the revolution ended. It's part of the sovereign transfer. It's still ours.
Representative Darby.
Thank you, Mr. Chair, and thank you, Ms. Forrest, for taking my question. Can you explain the waiver process? and how that you would use if a case, you said there's many cases, comes before you, and what constraints DES has, or what guidance DES has to base the waivers on.
So right now, the term waiver applies to, it's in the second section, and we'll be very honest, we've looked at that and we're trying to figure out what exactly it is that we're allowed to waive. That is part of the language that is unclear. And we believe it goes to issues of kitchen or bathroom size. This results to a very specific, those changes were made in relation to a very specific case or project that folks wanted to take care of in Portsmouth back in roughly 2008, 2007-ish. And they are very specific to the circumstances of that case. Part of what that was it allowed the conversion of commercial space to living space on the grounds that what had been commercial kitchen and commercial wastewater treatment would be reduced, the loading reduced. So it allowed the waiver of an expansion of living space based on the reduction of kitchen and bathroom loading. Using that as history and indicative of legislative intent, we believe that is a very specific, it's a very specific thing. But the other part of this is it didn't give us like rulemaking authority to develop waivers about those rules. And you have to go back in and look at that specific case and derive that. It is not a waiver that we have ever issued, because again, this is an area we would seek guidance.
Representative Taylor.
Thank you, Mr. Chairman. Thank you for being here today. You mentioned this case is pending legislation. Are there other, do you know if there are other cases pending legislation involving buildings over water? And if so, how many?
You mean other cases that we have applications for or that are being adjudicated?
Yes.
Okay. I am not currently aware of any cases that we have pending that specifically invoke this statute, this part of the statute.
Don't see any other lights. Thank you for your testimony. Is there anyone else that wishes to testify on SB 27? I'll ask one more time. Anyone else to testify on SB 27? Hearing none, I close the hearing on SB 27 FM, and I open the hearing on SB 241F.
Mr. Chair.
Oh, the blue sheets, yes. Thank you.
On the blue sheet, there is, on Senate Bill 27, 4 people signed up as pro, 1 person as con. And online, there are 3 supporters and 2 opposed.
Could you repeat what you just said, the last one?
Online is 3 support, 2 oppose.
3 to
Blue
2.
sheet, 4 support, 1 oppose.
Thank you very much, Representative. SB 241 FNA, relative to construction of a public pier on Hampton Beach and making an appropriation therefore. Our first speaker is the prime sponsor, Senator Evard. Senator.
Well, hello, everybody. I'm Senator Avard. I represent District 12, and this is my bill. And I appreciate the time that you have to listen to it. Basically, as you see in the amended analysis, this bill establishes and makes an appropriation to Hampton Beach State Park Pier Fund, a dedicated fund to be administered by the Division of Parks and Recreation for the purposes of siting, permitting, designing, and construction of a public pier at Hampton Beach. Now, I want you to look at the cost. As you can see in the fiscal note, it's $1. $1. And what we did, because we know there are budget constraints right now, We are making it so that public, not public, but private donations, grant money can be put into the fund for the construction of the pier. Now, what had happened a couple of years back is we did a feasibility study and everybody voted for it. It was about $250,000. And they came up with some really good information as to the different costs and constructions of the pier. And then we did another study in the last sessions, $150,000 for access to the beach for people who are handicapped. So why a pier at Hampton Beach? If you go to Hampton Beach, you will undoubtedly see that there are people in wheelchairs. Over and over and over again, I am a frequent flyer at Hampton Beach. I love Hampton Beach. I think we've done a lot of construction at Hampton Beach. The beach belongs to the state. That is a place of destination for people from Berlin to Keene, Nashua, Concord, all around the state. That is a place of destination. And we've done a lot of work there, and it's beautiful. But there's one area that really needs to be addressed. And, I embarrassed my wife not too long ago. We were at the beach. It was in the late winter. We're actually walking the beach, and we've seen an old lady down by where the jetty is. I don't know if you're familiar where the jetty is, but there was a senior lady walking along the beach and told my wife, I'm going to go talk to her. And she said, don't, but I did. And I asked her, I said, so have you ever been on the jetty? And she said, no, I've never been on the jetty. Where are you from? She says, I'm from New York, and I've been coming to this beach since I was a little girl. I said, oh, interesting. And you've never been on the jetty? What do you think about a pier at Hampton Beach? And she almost broke down and cried. And she said, that would be such a beautiful thing. I said, why? So you could extend the season. You could go out there and enjoy what other people are able to enjoy. And by the way, my sister's over where the bathrooms are. She's in a wheelchair, but she's watching from a distance. She couldn't enjoy the beach. So the idea really kind of sprung from that. And then I've seen over the years soldiers, senior citizens in wheelchairs, and they're going up and down the boardwalk or whatever you want to call it, where everybody else is basically on the beach itself. I know the Old Orchard Beach has a pier, and it really draws a lot of income for Old Orchard Beach. And I've heard a lot of naysayers says, well, my gosh, we build a pier, it's going to break because of all the seasons. Well, how does Old Orchard Beach do it? How do the people in South Carolina and Florida and in California? They all have piers. I think this would be a wonderful thing for individuals who are handicapped to be able to stroll out on the beach, on the pier, maybe have a fishing rod with them, maybe do a wedding. But going out there and enjoying that mist on their face like we can, if we can walk on that beach. I really think this would be a wonderful thing for New Hampshire. It would be like the lighthouse at the Nubble. I'm going to go to the pier, and I'm going to enjoy that time. It'll be with grant money, with private donations, and it is at the state park. So the state park will manage it. But I'm hoping you agree with the vision, but I do also think we build a really nice pier. It will draw income into our state. It really will. And if they build a casino there, it'll just add to it. I know some individuals talked about, when we were talking about it in the Senate, they're worried about the seals. I was at Salisbury a couple of years back, and there was a dead seal on the beach, and everybody crowded around the seal. And, nature will take its course, but I can't imagine just a child that maybe have a disability being reeled out there and actually seeing a seal. That would just be fabulous. It would be fabulous so that they could enjoy what we enjoy. Now, we know there's a jetty, and there's a sign where the jetty is that says, enter at your own risk or don't enter, something to that effect. But people do. I've done it. and I'm a violator. So, but people get hurt on the jetty. And search and rescue house, sometimes just about every year, have to come and rescue somebody that falls into where the jetty is. This would be a safe place for them to go out and fish instead of slipping on the rocks and costing the local taxpayers, services, emergency services. You build a pier right, at the end of the pier, you could have a couple of Sea-Doos ready for rescue there. Again, we were at Salisbury Beach, and my wife and I, and we saw a surfer going out, or a swimmer going out of into the ocean. And that individual just kept swimming over and over again. We just kept swimming out. And everybody on the beach started standing up, like, where are you going? The Coast Guard went by, and the person just kept going out. Finally, we saw surfboards coming from both ends of the beach, going after that individual who kept swimming. Finally, the Coast Guard came and intercepted that person, even though they went past it at one point. The person had autism, didn't know what to turn around. The rescue came out on those little paddle boards. They finally got him back. And he was okay. But I'm thinking, you have a pier at Hampton Beach. You can have a couple of Sea-Doos parked at the front of it where they can do a quick rescue. Both sides. You can do some wonderful stuff there. So, and I like to fish. And if you like stripers, catch a nice striper. It's a fabulous feeling. And if you get on the beach and you go on the pier and you catch a striper, you'll enjoy it. And I think this somebody who is handicapped that can't do what we do. So I'm asking you for your help with this. We're not asking for anything other than $1 and to set up the fund. And really don't have much to add to that. Just this bill is a bill that I think will be a wonderful thing for the state, wonderful thing for the disability community, seniors, and us as well. So with that, I'll take any questions.
Any questions for the senator? Representative Vale?
Thank you, Mr. Chair, and thank you, Senator Avard. So I'm looking at the bill, and I am on line 24, where towards the end of the line it says, the governor is authorized to draw a warrant for said sum out of any money in the treasury not otherwise appropriated. So I'm just having difficulty clarifying what that is in my mind. Do you have a clarification for that is the question? Thank you.
The purpose of the construction of the pier, the governor is authorized, so it's $1. It's $1. Are you looking at the amended copy?
Yeah.
That was as introduced. No, this is $1. This says as the amended SB 241 as amended.
Representative Nab?
Thank you, Mr. Chair. Thank you, Senator, for taking my question. Notwithstanding the dollar appropriation, the estimate of 21 to 27 million, is there a sense of what the pier actually is intended to be? Is it just straight out and back pier? Is there a length of it? Is there a structure involved?
Yeah, originally, there are a few designs. You can look at the what they came up with the original estimations. I think there were 3 different estimations, and it could be whatever design you want, but it'll most likely be about 1,000 feet. And you're looking at from where the bathrooms are, which is about 400 to 500 feet to the shoreline, to about another 500 feet out. So, and it allows them to wheel out to it because you still have to traverse, obviously, the sand. I originally wanted it over the jetty, but that would seem to be too difficult. But again, it'll allow for that to go through that narrow space and you can off ramp it as well. Also, horses like to use that area, so have to be enough room for the horses that like to go onto the beach through that access way. So, did I answer your question? No, so some people want a Ferris wheel, some people want, no, this is really just designed to go out there. Maybe a couple of areas where where they're indented, so you could park your wheelchair, or at the end, maybe it looks like a thermometer or something like that, so people can just sit there and relax and enjoy it. But I guarantee you, that'll be a big draw for the state, and people, it might extend the season where rooms and meals might be affected in a very positive way. So,
Representative Donnelly.
Thank you, Mr. Chair. Thank you for taking my question. So I've lived in this area for over 30 years, and I've seen many harsh hurricanes, harsh winters, harsh things that can happen to the frontage. What happens when the pier gets damaged by the Mother Nature? Who repairs it? How does that get funded?
well, it'll be funded through the existing mechanism. Also, if the state wants to get involved with that, they can do that as well. I know exactly what you're talking about because for a living, I do flood damage, and I visited Hampton Beach a few times this year, and there are instances where, yeah, there was a lot of damage to homes that were a few streets back. However, Old Orchard Beach is surviving. They have the same winters we have, probably a little bit more extensive. All the southern states have it. They have piers. They got the Hurricane Alley down there in North Carolina. So they manage with it, and there are piers that still survive. But there's a lot of obstacles in the way of this. But at the same time, I think we can be a little bit of visionaries here. We build things, we can make them built to last, and I'm hoping that's something we can do.
Representative Lunny.
Have there been any studies or projections of what this pier could bring in for extra revenue for local businesses, based on the hospitality industry?
We were in search of that at Old Orchard Beach, but I guarantee you they're making a lot of money as a result of that as a place of destination. And that's one of the areas, there's rumor that there might be a casino built up at Hampton Beach as well. And I have a feeling that would be one of the areas that people would just like to gather around. I can only think that it's be a very positive effect.
Representative Gould.
Okay, thank you for taking my question. I didn't quite understand where you thought the pier might go.
So you know where the state park is at the end?
Yeah.
Right. So as you know where the bathrooms are?
Mhm.
There's a little alleyway that goes right through there. It would go right through that alleyway as straight out.
Would it be over the pier over the jetty or next to it or what?
It'll be a distance from the jetty, but going straight out.
So would it be over those rocks that
No.
come out?
No, they wouldn't let us do that. The Army of Engineers or Army Corps of Engineers had issue with that. So that was my first plan. I thought that'd be a great place for it, but I'm not an engineer. But maybe they could restrict the access to that as well because of all the injuries that happen every year from that.
Representative Darby, then Representative Bridle.
Thank you, Mr. Chair. Thank you, Senator Aver, for taking my question. I love to fish too, honestly, and I've had a lot of good experiences down in Florida on piers fishing. Although I do think that people would still go out on the rocks because it's more about the riverway that brings in the stripers than and people can cast them shore. But my real question is, I'm looking at the original study, I think back in early 2020s, and it looks like the costs for the cost estimates were somewhere around no less than 12 million up to, probably 20 million total.
24.
And this bill seems to sunset the fund in 2035. And I believe what it says is that the funds are going to be returned to the state park gifts and donations account for other purposes.
For access to the handicapped as well. If enough funds aren't raised and we can't go through with it.
I'm sorry, just one more second.
Yeah.
Thank you. What the other part I read in the study, though, which was interesting to me, is that it estimated a 10-year time frame. The study itself estimated a 10-year time frame to build the pier. So somehow funds have to be raised to cover the cost. Let's just say 12 million, and then construction has to begin, and then all the funds are going to be recouped by 2035. This just doesn't seem feasible with the way this bill is structured.
It won't be built unless the funds are there. And if there's not enough funds, then it will go basically to making sure that the whole original intent of this is so that individuals who are handicapped, people who are with disabilities, will have access to the beach like we do. And if we can't get enough grant money, if we can't get enough private donations, then that's the plan B, that money will go. But there will be no construction prior to the proper amount of funding.
Thank you very much for that answer, Senator Avard. With respect to the accessibility, because I can understand that, I also read through skimmed through the study that was done, the accessibility study, which was pretty extensive, and it covered a lot more than access to the beach. It covered sort of all the accessibility challenges to Hampton Beach in general. This pier only appears to cover a portion of the accessibility concerns that were raised by that study. Do you have any thoughts on that?
We should definitely address them, but this is one part of the fix.
Thank you, Mr. Chair, and thank you for taking my question, Senator. My concern, for full disclosure, I represent Hampton, and I've talked to a lot of people about this bill. My concern is I know the state park fund right now is having difficulty funding other projects in the state. I share some of the concerns that were mentioned earlier about storm damage coming in. I lived in the Carolinas for 10 years and have seen some piers hold up. I've seen some piers get demolished. And if something catastrophic were to happen, I worry about who is liable at that point for coming up with the costs of repairing that. It appears, reading over this, that perhaps that maintenance or repairs from damage would be covered by the state park fund. And I would just be concerned that that fund might be depleted to an exorbitant amount if something catastrophic would occur. That being said, I appreciate your advocacy for the beach because I do think you raise a lot of wonderful points. And it seems that you have done due diligence in making the appropriation on this $1 in hopes that this will move forward. I think for a better time when maybe the state is more fiscally able to take on a project this. My main concern is that the state park fund, I know they're a self-funded entity, and how you envision over the years to come being able to maintain such a big project, because I think it would be a draw as well. Do you have any thoughts on that?
Well, we definitely want to make sure that I happen to be the chair of Energy and Natural Resources, so that's a big concern. We want to make sure that the funding is appropriate. And right now, I think we're having issues with our budget, right? So I do think that if we do bring the pier in, we can probably drop some mechanism for that to be, whether it's an extra fee to go on to the pier or parking, wherever that could help sustain the maintenance, if you will. I know that you're from Hampton, and I know there's about a 50-50 love-hate relationship with the state. Yeah. So, but again, I walked up to, and I'm very bold to do this, but I walk up to the people that are in the wheelchair and I say, "What do you think? And they love the idea, you know, and unless you're in that predicament, it's my heart goes out to them because I do love to fish. I do love the ocean. I love the Hampton Beach. I've been there since that was one of my favorite places as a kid. Used to take a bus there for $3.50 with my friend Norman. That I don't know how my dad let me do that. But you have the seashell. I mean, it's not right directly on the beach, but I mean, that could also suffer damage as well. There's other areas that could suffer damage, but you know, we'll build it, and we'll build it so that it's strong. I've gone to Florida. It was at Fort Pierce. They have a pier out there. That sucker is strong, man. There's nothing that's going to beat that down. And you see plaques all along the walkway where people fish and people have died and said this is Harry's favorite spot. This was Susan's favorite spot. And it's busy. You know, there's swing sets on there. People just want to sit there, and you know, the wheelchair out there. And I just think there's a lot of positives. Yeah, there could be some roadblocks, but we can manage that. And I think just being a little bit of visionary about this, and you know, in a time where we're kind of struggling with our budget, I'm hearing everything, but we also, you know, we put what, $20 million towards the COG. I've never been on the COG, but I've been to the beach, and millions of people go to the beach, and so I think again this would be a better draw. It will definitely. I guarantee you the people, you know, Smith and Gilmore is going to love selling bait. You know, the restaurants will love it. The casinos will love it. And the people that want to park in there, having that access, I guarantee you they'll love it. Yeah, storms come, storms go. Piers win, some of them, you know, break down. But I think we can build it in such a way that, you know, not, you know, things happen, but I think we can build it in such a way that it'll be a real positive thing for us, you know. So,
Any other
Yeah.
questions for the senator?
Mr. Chair, I hate to say this, I'm supposed to be at another one, doing another prime right now. So if I can be quick on these, I'll take the question.
Can you
but-
respect him and be quick?
Yeah.
Okay, so we'll start with Representative he waves off.
Thank you,
And
Representative.
she waves off. Thank you, Senator. I guess you
Thank-
gotta go.
Thank you all, and I appreciate it.
Thank
and,
you.
Have a wonderful rest of the day.
Up next, Representative Munns opposing the bill.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Chris Munns. I am one of the 4 state representatives from Rockingham District 29, representing the town of Hampton, the same district that Representative Bridle represents. This is the 4th bill with construction of a pier on Hampton Beach in its title introduced since 2021. SB 100 was introduced in 2021 and established a study committee to study building a pier over the jetty at the Hampton Beach State Park for access for people with disabilities. SB 346 was introduced in 2022 and appropriated $150,000 to study the feasibility and impacts of constructing and maintaining a pier directly south of Boar's Head in the town of Hampton. SB 122, introduced in 2023, initially proposed to appropriate $22 million for siting, permitting, design, and construction of a pier. This bill, SB 241, which was originally introduced to appropriate $12 million for the purpose of constructing an accessible public pier in Hampton Beach, the bill before you today was amended by the Senate to establish a pier fund and provide it with an appropriation of $1, clearly in the hopes that the fund might identify other appropriations, gifts, grants, and bequests that could be used to build a pier. It's worth noting that none of these bills was sponsored by anyone from Hampton. I appeared before the Senate Finance Committee in 2023 to oppose SB 122, and again this year to oppose SB 241, this bill.
I'm here today to continue my opposition to this bill and to also provide you the perspective not only of one of Hampton's state representatives, but also of someone who has lived in Hampton, 3 miles down Ocean Boulevard from the main beach where the proposed pier would be located, year-round for the past 28 years. The Hampton Beach State Park Pier is a mystery to most of my constituents. I certainly cannot speak for Representative Bridle and those of our constituents he interacts with, but most of the residents I have heard from, A, do not know anything about a pier, and or B, do not believe it is necessary. They and I are concerned about what it will do to traffic and to the already difficult task of finding parking at the beach. Our concerns are the greatest with regard to the 2 proposed locations at the north end of the main beach, particularly the one closest to Boar's Head, where traffic is already congested. Those 2 locations are in front of mostly residential properties, far away from the main entertainment and businesses along the beach. Those of us who live in Hampton year-round are also very concerned about the additional burden a pier would place on our existing hard roads, wastewater and water systems, and soft police and fire infrastructure. The taxpayers of Hampton are already absorbing a greater share of the costs associated with visitors to the Hampton Beach State Park than the share of state revenues we are receiving. We would want to be assured that when those costs go up, if a pier is constructed, we will be appropriately compensated. Following the public hearing on SB 122 in 2023, the Senate Finance Committee saw fit to reduce the proposed appropriation from $22 million to $2 million. That proposal, wisely in my opinion, was then laid on the table by the Senate. Nevertheless, $150,000 for an additional study performed by the same consultant who had prepared the initial feasibility study was included in the state budget approved in June of 2023. That study characterizes the project as an accessibility improvement that is, quote, high cost with moderate public support that has physical, environmental impact and moderate connection with other facilities. In short, a project that is nowhere near ready for prime time. If the real goal is to provide individuals with disabilities easier access to the water, then there are ways that can be implemented almost immediately and at much lower cost. We do not need to build a pier to accomplish that goal, certainly not one that is removed from the rest of the action on Hampton Beach. I sit on House Finance, and as we struggled and occasionally, shall I say, debated to put the budget together, I heard repeatedly from my colleagues that we simply do not have the money to pay for everything, and we must choose between must-haves and nice-to-haves. We have already spent $300,000 with a consulting firm working out of Portland, Maine, on one of those nice-to-haves on a project that is nowhere closer to the starting line, let alone completion, than when it was first proposed almost 4 years ago. I would also venture to say that at least some of our constituents are likely to be very concerned, dare I say disappointed, if they knew we had already spent $300,000 on 2 studies that are now gathering dust on a shelf somewhere. I do not believe that you should recommend this bill as ought to pass, and I urge you to recommend it to the full House as inexpedient to legislate. However, if you do believe we should create a mechanism to raise money to invest in Hampton, then please do so in a manner that will address the significant flooding issues so many of Representative Bridle and my constituents who live in their small family cottages in the Hampton Harbor area experience every time there is a storm or an unusually high tide. Something along the lines of what I proposed to you in HB 595, which you so wisely chose to retain for further real study. Thank you for your time, and I would be happy to answer any questions you might have.
Representative Vale.
Thank you, Mr. Chair, and thank you, Representative Munns. So my question is basically the south location for this potential pier is right smack through the piping plover nesting area. And I wonder if any of these bills have been specific enough about environmental problems that we have there.
There may be a couple piping plover spots. There's a location at the north end of the beach as well as the south end of the beach. And interestingly enough, at the north end of the beach is one of the recommended locations. That's the one that's referred to as the closest to Boar's Head. It's been a while since I've looked at the first study, which was the more detailed study on the pier, and so I can't recall how much they really got into the environmental issues. But you certainly raise a good point. That is a concern.
Thank you.
Representative Lonnie?
Said it's estimated to cost 22 million. Is there anywhere in the bill where you have to achieve all those funds before building begins? Or can you start halfway through or?
Well, there's nothing in this bill as it was amended that would provide that money. I mean, but the original bill, one of the original bills that was submitted, I think it was the one SB 122, did include an appropriation for $22 million, which at the time was the estimate of what it would take to complete the pier. Does that answer your question?
Can I have a follow-up?
Follow-up.
What happens with donations if you achieve like halfway? Like you get 11 million, you build the pier halfway, and then we hit a recession. No one's donating more money. Who's responsible to complete the pier?
I mean, that's a very good question. Reading the bill, it looks like that the money could be used to build a shortened pier if that made sense. Or that money could end up going back to the general fund, and in which case, I guess there's a potential credibility issue, which is, you ask people to make donations towards a pier, but you're not building the pier and now it's being used for some other purpose. So I think that would be something to consider as you're considering what to do with this bill.
Representative Darby?
Thank you, Mr. Chair. Thank you, Representative Munns, for taking my question. Did the Hampton Beach, the position of the Hampton Beach Area Commission on the pier?
Well, it was the Hampton Beach Area Commission that actually received the money for the initial study, and then they let it out to a consultant. I believe that they have taken a position in the past that they support it.
Follow-up?
Thank you again, Mr. Chair. And as a follow-up, you mentioned the second study, which was the accessibility study, I believe. Are you aware of any efforts made by the legislature to appropriate funds or other vehicles such as this to meet the funding needs of the broader accessibility study?
I'm not sure if this is what you're asking, but I'm not aware of any follow-up work that's been done following that study. But I do know that the State Parks Division has been, doing what they can with the resources that they have available to make the beach more accessible. There are mats that they place out in the summer to allow people on wheelchairs to get out into the beach. They also have the big wheeled wheelchairs that are available to take people out onto the beach. So they're doing what they can. There's certainly more that we could do along those lines. But so.
Anyone new? One more, Representative Vale.
Thank you. Where the state parks already has a lot of responsibility for storm damage, and as well as the town of Hampton, do you see is this potentially becoming, for maintenance and storm damage, that you would have to pick up the tab in Hampton? You would need to collect taxes from the residents or whatever was required to cover that.
Well, I would expect that, just like any other structure that is built in this at the state park, that the state would have primary responsibility if there was any damage. Having said that, you know, the town of Hampton, the first responders in Hampton, inevitably get drawn into emergencies of that type, and so there is an impact. There could potentially be an impact on local tax holders. If there's one other comment that I wanted to make that I neglected to mention, I mean, there's discussion about, you know, the pier would run right out from where the bathrooms are. Well, there's two different locations of bathrooms. If it's the central location, I think I think there'd be a real challenge, and I think a lot of the businesses in Hampton Beach would have a concern if the pier was to run right out down the middle, because that's the prime beach area. And taking that away from the public, and, you know, whenever you have a pier, it kind of bisects the beach. I think that would be a real issue. So I don't know that that's really a feasible alternative. So you're talking about locations that are on kind of the edges, and then you get into the question of, well, okay, they're on the edges away from where all of the activity is. Is that really going to be that attractive?
Thank you. I see nobody raising their hands. Thank you very much, Representative.
Thank you.
Appreciate your testimony. In support of the bill, Vanessa Blaze. She's my last pink card.
Thank you, Mr. Chair, members of the committee. My name is Vanessa Blaze, and I serve as the Director of Policy and Planning for the New Hampshire Council on Developmental Disabilities, and I'm here today to express the Council's support for this project. We have been in contact with the Commissioner of Natural and Cultural Resources, who has expressed a real intent on making recreation accessible in New Hampshire. And New Hampshire has been doing a really great job doing that. The council itself has provided funding for different projects such as all access trails and also for an accessible boat launch in the Lakes region. And we are very excited about continuing our work to make recreation more accessible for people with disabilities and their families. Disabled people and their families travel, and they spend money, and they choose to travel in the places where their loved ones can enjoy the things that they're enjoying. And it is to the benefit of New Hampshire that we unlock this untapped market of people with disabilities who want to travel, want to enjoy the beauty of New Hampshire. And we think that it is a great economic decision to make. I've heard a lot of concerns here today about this particular project. You know, we understand that the study has been done and that an environmental study was done, and we're happy and comfortable with the recommendations that are being made. We recognize that there are some tools of access at the beach. We believe that they're not really optimal. For example, the mats. One of the issues with the mats is that they don't go out to the water. They're seasonal. They have to be brought in and out. And as of right now, the recreational wheelchairs, there's only 2 of them as far as we know, and those have to be pushed by someone. So someone couldn't independently use those to access the area. So to recap, we are in support of this. We hope that the state continues to do these types of projects and support these types of projects to make recreation more accessible in New Hampshire and to make it a more welcoming place for people who want to travel here.
Questions? Representative Ryan?
Thank you Mr. Chair, thank you for taking my question. I'm not very well versed in accessibility, but I do go to Hampton a lot. I envision this pier. How do the people get from the parking lot to the pier?
Well, the pier would my assumption would be that it would have a ramp system that they would be able to just access right onto it.
So from the parking lot where the North Beach is out?
Well, it would
then
be
out to the
from,
pier.
so my understanding that they want it to come from where the bathroom area is. So where the bathroom area is like a raised concrete area. And the parking is accessible from there. So it is already accessible to get to the bathrooms. And then outside of that is already like a raised concrete area, and the pier, my understanding, would come off of that.
Representative Darby, did you have your hand up?
Thank you, Mr. Chair. Thank you very much for taking my question. I'm curious if, I didn't hear the name of your group, but I'm curious if you've also reviewed the accessibility study that was done, the second study that was more provided a broad set of recommendations for improving accessibility, and if you have a comment on those recommendations.
Are you referring to the full study that was done?
So the first study was the peer study,
Mm-hmm.
and then the second study that was done was specifically on recommendations for accessibility to the beach. So the second study is
To
what
the
I'm
state
wondering.
park itself?
Yes, to all the beaches in Northampton State Park, yes.
Okay, yes. So we did, we were able to review a study that was put together by the commissioner. And we were actually part of helping get advocates together in order to give feedback on that study. So we have had some participation in it. And we did review the study. We're very excited about the plans, or the hope for plans. And what we really appreciated is that the commissioner and their team prioritized. And so we have like a spreadsheet that has like the different projects that they would like to see happen, and then the priorities of those projects, who would be involved in implementing those projects, and kind of like a timeline. And we agree with it. We know that one of the things that they're going to focus on specifically is the parking issue, which is an issue anyway, right? Whether we build this pier or not, with all of the construction and expansion of the casino and whatnot. So that's already something that's being looked at. And we're happy with the work that's going on with that, especially since the parking will involve the need for accessible parking, or an availability for people to be able to get from remote parking areas to the beach itself. So we have had an opportunity to look at that. I hope that answered your question. Okay.
Representative Taylor.
Thank you, Mr. Chairman. Thank you for being here today. Has your council received any pledges of support by benefactors or business groups? If yes, how much have they pledged?
We do not ask for sponsorship. The New Hampshire Council on Developmental Disabilities is a federally funded state agency that's mandated out of the Developmental Disabilities Act. We do not take in any money. We don't take in sponsorship. Our support is through our advocacy. Our council is 60% people with developmental disabilities or their parents or guardians. And so what we do is we connect people with the lived experience of developmental disability with collaborators who want to do these types of projects. And then we can just kind of connect them with people who would be interested in being part of that support. But we do not take any pledges in. We do not fundraise or promote sponsorship of anything.
I don't see any other questions. Thank you very much for your testimony.
Thank you.
Is there anyone else that wants to testify on SB 241 FNA about Hampton Beach? I'll ask a second time. Anyone else to testify on SB 241 FNA? Seeing no one approaching the speaker's table, I'll close the hearing on SB 241 FNA. I'll now open
Mr.
the
Chairman.
hearing on. Oh, yes. Thank you, Representative.
The blue sheet, 2 are in support, and that's the only 2 that signed up. Online, 2 are in support, 6 opposed.
Thank you very much. So now moving on, SB 299, relative to penalties for contractors violating water pollution and waste disposal regulations. The prime sponsor, Senator Pearl. Welcome.
Good morning, members of the RR&D Committee. It's great to be back over on the House side of the wall again. For the record, my name is Senator Howard Pearl. I represent District 17, and I live in the town of Loudon. I am here today to introduce Senate Bill 299. The existing penalty provision in the Shoreline Protection Act does not adequately address professionals such as contractors who are willing to complete a job without the necessary permit, or who ignore the approval criteria in an obtained permit. In such cases, the contractor receives an unfair advantage over more reputable competitors, and the landowner is left with the ramifications of correcting the violation when New Hampshire DES makes them aware of it. Many property owners rely on contractors to know what type of work is allowed under the law and what permits are required to do the work. Most contractors follow the law and work with the property owner to develop the project that will qualify for a shoreland permit. However, there are a few bad actors who regularly cause violations without the knowledge of their clients. Under RSA 483B18, as currently written, we can only pursue an administrative fine or penalty under the Shoreland Protection Act if there is a failure to restore the site within a year after the DES agency has provided notice of the violation. If there is a failure to restore, DES can pursue an enforcement action against both the property owner and the contractor. However, if the property owner appropriately cooperates with the DES agency to restore the site after receiving the notice of violation, then DES has no mechanism to bring an enforcement action against the contractor who did the actual violation. Additionally, the property owner might pay the same contractor again to do the restoration work on the property. This amendment is, or this bill is meant to close that loophole. So this went through the Senate with no objection, and we do have members of the DES team here that can answer specific questions if you have them about the Shoreline Protection Act, but I would appreciate your support on the bill. Thank you.
Any questions for the senator? Seeing none, thank you, Senator.
Thank you so much.
Our next speaker is going to be in favor, Andrea Lamoureux, New Hampshire Lakes, and then next up will be Darlene Forst of the DES.
Good morning, Chair and members of the committee. It's been a while since I've been here. I'm Andrea Lamoureux, president of New Hampshire Lakes. We are a statewide nonprofit organization. Our mission is to restore and preserve the health of our lakes. We represent hundreds of lake associations throughout the state. And we are here in support of this bill for all the reasons Senator Pearl just explained. And you may have seen online, we have about 250 folks from our community who also signed in support of this bill. This bill really is pretty common sense to us, closes a loophole. Not only does it help protect our lakes from those few contractors who, for whatever reason, don't follow the Shoreline Protection Act, it also protects homeowners that live around these lakes who want to do the right thing and maybe inadvertently hire someone who, for whatever reason, doesn't want to do the right thing when it comes to their project. So with that, we urge you to support this bill, and always happy to answer any questions.
Any questions for the speaker? Representative Darby.
Thank you, Mr. Chair. Thank you, Ms. Lamoureux, for taking my question. How would this bill work in your from your perspective in terms of finding the contractors? At what point, from your perspective, would DES be able to find the contractors, and how would that be different from the penalties or the reclamation made on the homeowner, or the asked of the homeowner to sort of repair the waterfront?
Thank you for the question, Representative Darby. I'm not the expert in this area, and we do have an expert here, Darlene Forst from DES. My understanding, again, right now is that there's really no mechanism, no mechanism for the contractor to be fined if the property owner currently goes through restoration. So I'm going to defer that to Darlene, knowing that the department has most likely thought through this. And I will say, and I know Darlene, Ms. Force will corroborate this, that the department always tries to do an education first approach. There probably are some contractors out there, for whatever reason, don't know the rules and the laws. And I'm confident that DES would try, and when appropriate, to do an education first approach. Thank you.
Representative Vale, then Representative Donnelly.
Thank you, Mr. Chair. Just quickly, Ms. Morrow, and thank you for coming today. Just went right out of my head. I'll come back. Thank you.
Maybe. Representative Donnelly.
Thank you, Mr. Chair. Thank you for taking my question. So last term, there was a bill that was passed that says you're not allowed to fertilize in front of a storm drain across the state, and that had passed. My question is, if a contractor doesn't know and they decide or it just happens, and they're in the middle of not anywhere near close to a lake, how does this bill affect that contractor? Does it affect them at all?
Thank you for the question, Representative Donnelly. Excellent question. The Shoreline Protection Act does have setbacks for fertilizer. The bill you referenced last year was different. It had different stipulations for fertilizer, and it extended outside of the Shoreline Protection Act. So I would say the Shoreline Protection Act, what we're currently talking about, there is fertilizer setbacks, and which the contractor would need to comply with. And again, I'll defer to Ms. Force for a more complete answer. Thank you.
Do you remember your question?
I did, and I just wanted to double check to make sure the language, because I see that this is as introduced by the Senate. Was there any amendment that you would have suggested, or?
Thank you for the question. No, we are in full support of as it was introduced to the Senate. Thank you.
Any other questions for our speaker? Seeing no hands or lights, thank you very much for your
Thank you.
testimony. And my last card, Darlene Force, DES.
Thank you, Mr. Chair. Again, my name is Darlene Forst. I'm the current Wetlands Bureau Administrator at the New Hampshire Department of Environmental Services. Shoreland protection is currently wrapped in, staff-wise, into the Wetlands Bureau. Therefore, I'm here to speak on this. We have circulated a letter of testimony which explains the department's support for this legislation already. Will not go into a great deal of detail other than to reiterate what Senator Pearl had mentioned earlier. The way the law is structured, it talks about a homeowner, if after a year they haven't made restoration. What that doesn't do, or what that doesn't allow us to address, is when the same contractor shows up on multiple projects in rapid succession, where, for instance, there was no permit pulled. An example on fertilizer, the issue of storm drains, not part of shoreland. But there is a restriction on fertilizer within 50 feet of the water. I believe it's more specifically within 25. If we were to find a landscaper who is spreading fertilizer, you can't go pick that fertilizer up. You're not going to go up and you can't get it out of the soil once it's applied. There are workshops to educate folks. If we find a contractor who's spreading fertilizer, if ChemLawn is out there going through and adding fertilizer, that is irreparable harm, and they're a licensed professional. We would hope they would know. And we would probably tell them the first time, you ought to know better. Every successive time, it doesn't make sense that we would wait a year. And it doesn't make sense that we would go after each individual homeowner when the most knowledgeable party would be the contractor who makes that their day-to-day job. If in the realm of construction, when you have, for example, if you were to have a contractor who in a period of one construction season, we find on 4 to 5 different job sites where the site is opened up and dirt is exposed, the permit hasn't been issued yet. as a construction professional, if you're in the protected shoreland, you should know that you need a permit if you're exposing soil. And that would be a case of, we would attempt to educate the first time, but if the next construction season we were to go out and find that same contractor again, what we frequently hear from homeowners, many of whom have second homes, is, well, I hired somebody local because I figured they knew. It would be great if, we would all like folks to come here believing that when you hire local, that's exactly what you get, is you get good, reputable service. It hurts all contractors if a contractor does that to someone. We hear from contractors that it's not fair that they told this person that they couldn't take the job because you need to get a permit. Some other individual said, yeah, I'll be there in about 2 weeks, does the job, leaves. They got the money, they're gone. The homeowner's left holding the bill for fixing it. They might not be able to get the same contractor to come back and do it depending on what their contract says. It might cost them more to litigate than the contract was originally worth. We get these complaints. When we were talking about the homeowners, we pointed out the fact that education is first. Most homeowners come to us once, and we see the contractors again and again and again. And ultimately, they're as much a partner in the success of our water quality protection as anyone else. So this to us is a very valuable tool. We think of it more as incentive to adhere to education than anything else. We're not looking that we really want to go out and fine people right and left. And for the record, the fines do go into the general fund. There are some folks that we need to encourage them to please work with us. I would be happy to take any questions.
Representative Taylor.
Thank you, Mr. Chairman. Thank you for being here again with us. This is not so much a question, but a comment. We tabled a bill earlier that increased penalties for administrative fines because they weren't being written. I'm hoping, if this goes through, that DES does take action with this. It's a good, I'm positive on this particular proposal. Thank you.
Representative Darby.
Thank you, Mr. Chair. Thanks again for being here and taking my question again. One of the final statements you made was that this was intended as an incentive for contractors to adhere to education. Can you describe some of the opportunities for contractors to be educated on the practices, best practices?
We, unfortunately, since the outbreak of COVID, don't have as an aggressive outreach strategy as we used to. There are various workshops through Nanners. There are outreach events that various towns have put on. We have worked in the past with New Hampshire Lakes Association to provide speakers and educational opportunities. We have, for the really large contractors, we routinely go and speak to members of AGC. We presented at GSOA just 2 weeks ago. GSOA is the what used to be Granite State Designers and Installers. There's a lot of crossover with the septic designers and septic installers on shoreland regulations. We provide speakers wherever we can. Plus, we provide fact sheets, information on our website, and we're starting to move into video production as well. We take every opportunity that we can, and hopefully, as things improve, we can perhaps get back into DES-sponsored, tailored to different contractor groups, outreach events.
More
follow-up.
Thank you again, Mr. Chair. One thing I noticed about in this bill was that the term contractor is not defined, and it's not defined in the broader title, the broader chapter either. It is defined in other locations in statute, And it's also been defined in other bills that have been brought forth that sort of specifically called out contractors. And I wonder if DES would be willing to help craft an amendment to define the definition of contractor as it applies.
We would not be opposed to defining the definition of contractor. That can be done in statute. We do also have authority to define certain terms by rule. And the shoreland rules need to be readopted in 2026. So whichever mechanism this body would prefer, happy to have a definition of contractor.
Any other questions? Don't see any hands raised. Thank you very much. Appreciate your testimony. I don't have any other cards. Is there anyone else to testify on SB 299?
Written testimony only on behalf of the New Hampshire Lake Management Advisory Committee and New Hampshire Rivers Management Advisory Committee, both in support.
Can you still fill out a pink card and pass it forth from my clerk?
I'm staff to the committees. I'm not
Oh, okay, thank you. So we'll just pass that around the blue sheets. Representative Sargent?
On the blue sheet, 2 in favor, and that's it. Online, 282 in favor, and that's it.
Thank you very much. I'm now going to close the hearing on SB 299 and remind everybody we're back at 1, where we'll have the hearing on SB 110. Then we're going to break for caucuses, and we'll be back at 2 to exec these 4 bills. So you're free to go to 1 o'clock. Thank you. All right, I got to bring this to the clerk. I got to go see the speaker.
Is he back? Is he back, the speaker?
Well, I don't know. I emailed him about Norm Major dying, and I didn't hear from him, so I wanted to make on Senate Bill 110 FN relative to terrain permitting. Our first speaker will be Peter O'Neill, who's here to speak on behalf of the prime sponsor, Senator Lang. Mr. O'Neill.
Thank you, Mr. Chair and honorable members of the committee. My name is Peter O'Neill. I'm the Senate Communications Director. I am here on behalf of Senator Tim Lang. He is currently in caucus right now, so you'll have to deal with me in his stead. He very much appreciates you considering this bill, though. I do have to mention that I will not be taking any questions, and there will be people behind me who are probably a lot more knowledgeable on this bill than I am. So Senate Bill 110 is relative to terrain permitting, and the version amended by the Senate is as follows. It establishes fees for applications for terrain alteration and requires that the Department of Environmental Services is to adopt rules to establish by notification for certain projects with plans encompassing an area less than 150,000 square feet. And I believe that the effective date is 60 days after passage. That's all I can say at this time, Mr. Chair.
Well, thank you. And since you're not taking questions, thank you for your testimony.
Thank you very much.
Okay. Speaking in support of the bill, Matt Mayberry.
Good afternoon, Chairman and Representatives. My first time before you folks. My name is Matt Mayberry. I'm the CEO of the New Hampshire Home Builders Association. We're the leading voice in residential real estate, not real estate, that's my other hat, in real estate development here in New Hampshire. We have 27,000 men and women who work in the residential building trades. And we add $5.4 billion into the New Hampshire economy. This will help our housing crisis that we're in right now. And the best part is it costs the taxpayers nothing to do this. I know, it's surprising because usually people come to you looking for money. I'm saying help us just change the process a little bit. This is exactly what you folks have wanted forever, what we've all talked about. It's a private-public partnership in which that we're working with New Hampshire DES, and that there's a fast track program that would be paid for by the developers. Again, no taxpayer dollars, paid for by a developer or builder to get these things done within 60 calendar days, business days. What we're asking for is if you would please consider supporting this amendment or supporting this bill and change the AOT from 100,000 square feet, the alteration of terrain. The threshold currently is at 100,000 square feet. We'd like to take it up, please, to 150,000 square feet. After that, regular processes go, but this does move things along quite a bit. I'm sorry, may I answer any questions at all?
Any questions for the speaker? Representative Gould.
Okay, thank you for taking my question. Okay, why do you want to increase it? The area.
Absolutely. What we have found is that if we go from the 100,000 to 150,000, New Hampshire DES will allow us to do what they call submit and build. And so we'd pull in all of the applications, put in all the paperwork DES was required, send it in with a fee, and then we could proceed building. And then they would review it. And if there's any problem with it, they'd ask the builder separately. This just enhances the amount of land that we could develop on without waiting for formal DES approval and stamps. So the feedback from as introduced, the original acreage was 200,000 square feet. But in talking with our home builders and our board of directors, they said if we could go just to 150,000 square feet, that'll get us what we need. Because what they're finding is, I think it's homes over, if you do 4 homes, it hits that 100,000 square feet of disturbed area. 150,000 will get you 6 homes. And a lot of our developments that are coming through the smaller subdivisions are about 6 homes. So it saves probably about 7 or 8 months of permitting process.
Point of order, Mr. Chair. Sorry for the interruption. I just want to make it clear to everybody. The bill that was left on our table for us is the as introduced and not as amended. The one that was sent out by the chair to this email, to this committee in an email, was the one that was as amended to the 150,000 square feet, whereas the one that was printed and left for us today was the original that goes up to 200,000 square feet, just so we're all on the same page. Thank you,
And
Mr. Chair.
Thank you, Representative, because what I did was I
Okay. A
grabbed the
follow-
one off the table, and so I was like, Peter, like, this isn't what we agreed to.
Okay.
So,
A follow-up, please?
Maybe Christie can double check on the right bill so everybody's looking at the right one. I'm not sure this is the wrong one, Representative Bridle.
Christie, here's that for you.
Yeah, but he thinks
What they
there's
have is
one
this
that
one
says
right here.
150.
That's what
It's as amended.
and this says 200,000.
Yes.
Well, this is amended, the one I'm looking at. So
Oh,
let's just
you-
take
you-
a moment, make sure we're
Sure,
all looking
sure.
at the right bill. Well, we don't know. Representative Bridle thinks we have the wrong one because the one I'm looking at doesn't have the number 150 in it. And we might be looking at the right one. I don't know.
It says
Chair-
amend.
Chairman, would you like me to step aside and then take another bill and then come back to this one when?
I'd love to do that, but we have no other bills. So if you want to just
Oh.
wait,
I'll gladly wait.
because I don't want to call up somebody else to speak to the bill if we're not looking at the correct bill.
Okay.
We'll just confirm that.
Can I still ask a question?
Question, Representative Gould,
Well, how?
but not for the speaker.
Yeah,
Are
yeah,
you going to
well-
ask the speaker a question?
Yeah.
Okay.
Okay, thank you. Okay, you said it's going down to 150,000, right?
Yes,
Okay,
please.
how many acres is in that? For one house, it would have how much acre-wise? Do you know? So I can picture it better?
3.44.
3.44 for
Yes.
one house?
Oh, no. It depends on what town you're building in.
Pardon me?
It would depend on the zoning requirements per municipality, because some have, and that's a totally other discussion. We have municipalities that would require a 1/4 acre, and some go up to 10 acres.
Okay.
And so I owe the good representative to my right a beverage. Thank you for the assist. And this is just one of many bills that we're putting together about housing. We're viewing it as a jigsaw puzzle, and that there won't be one silver bullet. It's just small things. And the 13 bills that the New Hampshire Home Builders Association are asking you to consider, they're not asking for any money from the state. It's really cutting red tape. It's cutting bureaucracy. We were thrilled on this when New Hampshire DES says, let's work together and find something that can work for all of us. Senator McConkey did a great job of sitting with them, working on this is what we want, that public-private partnership.
A follow-up question. Yes, Representative, go ahead. Well, I think somebody's passing around. No, did I see something? No. I thought you were asking him a question.
Yeah, my question, thank you, is what is terrain alteration?
Absolutely. It's when you're moving dirt. How much dirt are you disturbing? If you have, say, a pasture of 40 acres, how much earth are you disturbing, moving grass or trees? This keeps in compliance all wetlands, all DES requirements. This is just, imagine if you just had a pasture. There.
So I guess you're okay. So I'm going to throw a little wrench in this, and while we're waiting to confirm what bill we're really looking at, on behalf of the builders, are you aware that HB2 was amended by Amendment 1488H that covers this same topic when we passed HB2 as amended? Just, what was it, a week ago, 2 weeks ago?
No, sir.
Okay, because I didn't know if you were going to speak to that. Okay, just a question.
Okay.
Thank you.
Okay.
Representative Baldwin, would you like to hand me your amended copy?
Or Chairman, I can give you mine.
No, you can keep it, because we're going to get some more from our researcher.
So it's a really nice day outside. I just saw it from my office to the car, from the car to the building, so.
All right, we have more coming. Thank you, Representative. So while the actual amended bill is being passed around, would you like to say anything more on the amended bill?
Yes, sir. Just briefly, please pass this. It costs nothing, and it's that private-public partnership, once again. And we're the ones that scaled it back from 200 to 150. We didn't want to overreach. But this helps us a lot.
Any other questions for the speaker? Seeing none, thank you very much for your presentation.
Thank you, Chairman. Thank you, committee. Have a nice day.
Next up, Meredith Hatfield, the Nature Conservatory, opposing the bill.
Thank you. Good afternoon, Mr. Chairman, members of the committee. Meredith Hatfield for the Nature Conservancy. We do have some concerns with the bill that I will discuss, but we did want to thank the Senate committee for the changes they made. They definitely improved the bill. So a couple of things. One is that this bill seeks, I think, to help address the housing crisis, and we certainly understand that we do have a housing crisis that needs to be addressed. But so one suggestion we had is that this could be limited to only housing projects to try to be a targeted solution. Another concern we have is a positive aspect of the Senate amendment is it does increase fees. We do have some questions about whether those fees are sufficient, particularly since this will increase the number of projects that can be submitted as permit by notification, which, as you heard, means that the developer submits it, certifies, has a professional certify that it meets the requirements, and then they proceed, and then DES can audit or check on the project. And we're not sure if the permit fee increases would cover the additional staff time that DES would need in order to ensure that those projects are in compliance. And then generally, as I said, the Senate did improve the size increase to trigger the permit. And I actually had to look up what these square feet translate to. So 100,000 square feet is 2.29 acres. That's the current requirement. Moving up to 150,000 square feet is 3.44 acres, which is a reduction from the original bill. The 200,000 square feet would have been 4.59 acres. And those are my comments.
Thank you. Any questions for the speaker? Seeing none, thank you for your testimony. Bill Trowbridge from New Hampshire DES. And he's the last pink card.
Good afternoon.
For the record, my name is Philip Trowbridge. I'm the manager of the Land Resources Management Program at DES. The Land Resource Management Program has 4 bureaus: wetlands permitting, shoreland permitting, alteration of terrain permitting, which we're talking about today, and subsurface permitting, which is septic systems. I thought I'd just take a minute to talk about what alteration of terrain does. I don't know, we had a lot of discussions at this committee last session on septic systems, so this is maybe a different topic for us. Alteration of terrain permitting essentially is about stormwater management on large construction sites. We've talked about 100,000 square feet, that's 2.3 acres. These are the large construction sites. These are the big box stores. These are the 20 to 30 house subdivisions. These aren't single family homes. These are big construction projects. And they have three main objectives that we try to achieve through this permitting. First is erosion control. We don't want, sediment running off the site into rivers and streams and lakes and onto other people's properties. The other is maintaining the hydrology of the site, because you can imagine if you have a site that's not developed and then you pave it, there's going to be more runoff, and that often affects neighbors. It also affects town culverts under the roadways, and affects town ditches and things and other municipal infrastructure. And then the third aspect is groundwater recharge. Same situation, infiltration of water into the ground helps from rainfall, helps replenish our aquifers, which we rely on for private wells. We're running that all off into the ditches and running into the streams, then the groundwater table gets lower, which affects people's wells. So that's why we do alteration of terrain permitting. And as part of the process, an engineer, a qualified engineer, needs to submit a plan to us saying how they're going to do this construction to meet those objectives. So as been discussed earlier, the reason for this legislation is housing crisis and the need for permitting efficiency. And this is a governor level initiative from Governor Ayotte to speed up our permitting timeframes. And as Chairman Harb mentioned, this same language is in HB2 for that reason. And it is exactly the same language. The bill as amended by the Senate would direct DES to do this permit by notification process for projects between 100,000 and 150,000 square feet. That is not subject to the Shoreland Protection Act. And that was part of the amendment added on the Senate side. So these are projects that are more than 250 feet away from a lake, a pond, or a large river. It also increases the fees, establishes a fee for a PBN process. The fee increases in this bill, obviously relate to the PBN process, but they also relate to the larger initiative in HB2 to consolidate permitting with DES and moving some of the functions from NHB and New Hampshire Fish and Game to DES. So we have had a productive engagement with the development community and the development of this bill. We feel that the PBN process can work in these cases, and we can have the rules ready by the January 1st deadline. And we are aware of some of the letters that have been issued on this bill, particularly from the RMAC, which had some comments about the bill, about how can they do their reviews in the timeframes for a PBN, and the difference between the size of the protected shoreland and the quarter mile that they're required to look at. We feel like we can deal with that through the rules. Maybe I should back up on that. There was a letter sent by the Regional Management Advisory Committee on this bill, which made a point that they're required to look at projects that are within a quarter mile of a river, of their designated rivers. And when that's about a little over 1,000 feet is a quarter mile. When we talk about protected shoreland, that's only 250 feet. So there's a gap there. And also they take some time to do the reviews. And so a permit by notification process can take a little while. A permit by notification process can be fast, so that could be a problem. But we feel like we can deal with that through rules where we require that consultation in advance of the PBN submittal. So I'll pause there and see if you have any questions, and happy to discuss this further.
Let's see, Representative Bucco.
Thank you, Mr. Chairman. I'm looking at the fiscal note here, and the increase in the fees will be approximately 1.3 million. I'm assuming they came to you for this information.
Yes. Are you looking at the as amended by the Senate version?
I hope so.
Yeah.
Yes.
Yes, that's correct.
Well, the fiscal note is amended 3/17/25, so
Yes, that's
pretty recent.
That's the one.
And that's, so they're assuming the increase of 1.3 million is the increase in the fees.
Correct. With the fee structure that's represented in this bill, that's what would be the increase from the current fees.
Thank you.
Yes.
Representative Nab.
Thank you, Mr. Chair. Thank you for taking my question. Can you just clarify? So is the Senate amended version in HB2 or the original version?
The Senate amended version.
It is. Okay,
And
thank
we,
you.
We did double check that to verify that the language is exactly the same.
Okay, thank you.
Representative Darby.
Thank you, Mr. Chair, for indulging me once again. Thank you, Mr. Trowbridge, for attending and your testimony. I'm curious, so I very much appreciate the idea of there's professional engineers that are submitting these plans. My daughter is one of these professional engineers in Vermont, so I get it, and I trust them. But what happens when the DES reviews the permit and says, you know what, you missed something? What's the recourse?
Excellent question. We are planning to do some sort of compliance assurance auditing on this, some sort of random auditing, and that allows the contractors to get going on their projects, but also ensures that the work is done accurately. We have a whole compliance procedure that we go through, that if work is done that doesn't meet the conditions of a permit or doesn't meet the plans, we would require it be fixed, through that process. And that's a kind of a progressive level of discipline where, first you just request that something happens, and then if it's not done, you can move up to an administrative order or a more formal type enforcement. We find that 90% of our compliance is all done voluntarily. And so we would expect the same in this case.
Any other questions? Representative Nab.
Thank you, Mr. Chair. Thank you for taking my question. A suggestion was made to have this only apply to housing. Do you have any rough estimate of the breakdown of how many of these permits are for housing projects versus for commercial projects?
We've done these calculations, and we've looked at it from the wetland side and the alteration of terrain side, and I may get the numbers wrong, but I believe housing is about 30% of alteration of terrain projects. The challenge for us in doing that is that projects are very rarely black and white housing. There's oftentimes multi-use developments, and it might be difficult to separate them. So yes, a traditional subdivision, yes, that's housing, but something like some of these larger projects that have commercial and residential mixture, or some sort of redevelopment within a built environment, it'd be hard to say.
Any other questions? I have one for you, but I'm not sure you can answer it. But when I noticed that HB2 as amended by 1488H was the same language as this bill, my question is, why do we need this bill if it's already included in HB2 as amended?
Well, you're correct that I may not be the right person to answer that. But I guess what I probably could say to that is that Senate Bill 110 came first. And so it's been moving through the process. And so it needs to complete the process.
Okay, I know it was probably an unfair question, but I've been asking that question and I haven't gotten a real good answer. So I wondered if
Would
you
you
had.
consider my answer to be at least an okay answer?
It was an okay. It was an okay to be our last testimony in this session. So you can get a gold star for that. No other questions for the speaker? Thank you very much.
All right, thank you.
Appreciate it. Would you like to ask a question? Is there anyone else to speak on SB 110 FN? For the second time, anyone else to speak on SB 110 FN? Representative Sargent, what do we got?
Blue sheet, 1 in favor, 1 opposed. Online, 2 opposed, 1 in favor.
Thank you very much. And hearing that, I close the hearing on SB 110 FN. We're going to be adjourned. The Republicans will stay in this room for our caucus, and we'll come back at 2 to exec these 4 bills that we heard today. Thank you. Get a special room that says Big D on it, or? your name over there.
These all going on consent.
Probably not the Hampton Beach. She's not sure how her people would. Welcome back to Resources, Recreation, and Development. Our exec session this afternoon is on 4 bills, SB 27, SB 241, SB 299, and SB 110. I'll open the exec session on SB 27 relative to dwellings over water, and I believe Representative Donnelly, you have a motion to make?
Thank you, Mr. Chair. I'd like to make a motion to retain SB 27FN.
I have a motion to retain. I have a second.
Second.
Seconded by Representative Bridle. Any discussion on the motion? Seeing none, I'll ask the clerk to read the roll. Retain.
Yep. Motion to retain. Representative Davis.
Yes.
Representative Gould. Representative Donnelly.
Yes.
Clerk votes yes. Representative Bridle.
Yes.
Representative DuPont.
Yes.
Representative Lunny. Representative Taylor.
Yes.
Representative Nab.
Yes.
Representative Vale.
No.
Representative Baldwin. Representative Darby.
Yes.
Representative Ryan.
Yes.
Representative Bucco.
Yes.
Representative Sergeant.
Yes.
And the chair.
Yes.
15-1.
So you won't see that on the calendar because we retained it to add to our retained bills. When we're all done execing, I'll spend a moment and talk about our hearings on the retained bills. Closing SB 27, opening the exec session on SB 241 FNA relative to the construction of a public pier on Hampton Beach and making an appropriation therefore. I believe I have a motion from Representative Bridle.
Yes, I move to OTP.
And I have a second, Mr.
Yeah, I'll second.
Seconded by Representative DuPont. Any discussion on the motion?
Motion to ought to pass. We felt that it was appropriate to invest in projects that bring people together, and that with the appropriation of $1, this allows that opportunity to flourish in the future without putting the final project to bed. So that's why we decided to OTP.
Thank you. Does the second wish to speak?
Excuse me?
Do you wish to speak?
No. I'm in agreement with Representative Bridle.
Thank you. Representative Darby, you had your hand up.
Yes, thank you, Mr. Chair. So I'm concerned about the bill as written for three primary reasons. First off, the study, the Hampton Beach State Park Accessibility Feasibility Study, was just completed last October 2024 and provided comprehensive recommendations for increasing accessibility throughout Hampton Beach State Park. It did include one section of that did include the pier, but it had many other sections as well. And if we are interested in if we're truly interested in improving accessibility, which is what was mentioned by the sponsor, then I believe that this bill should be amended to provide funding for all of those accessibility improvements, not just one, which is the pier. Secondly, as has been brought up, the maintenance costs, if this were a bill, are going to be a significant concern. The original study on the pier indicated that maintenance costs are going to be somewhere between, say, $150,000 and $350,000 per year, and it's really not clear where that money is going to come from. That the difference is based on how the pier is built. And so, and this was brought up by many members of this committee, and we really didn't hear, in my opinion, a satisfactory answer to that. And thirdly, this study has, or this fund has a closure date of 10 years from now. The Pure study said that it was going to take 10 years to build this, while and there's also time that's going to be required to raise the something like $15 million to get that going. So while of course some work could start ahead of time, this fund is going to run out before it's able to complete the effort. So I don't think the bill is well constructed to begin with. While some might push back and say, well, then the funds will just go back into the general accessibility support for state parks. That's true, but it's 10 years from now, and that money could be better spent now. So I will be opposing this bill. Thank you.
Thank you. Anyone else wish to speak on the motion? Representative Vale.
Thank you, Mr. Chair. I will be voting against the ought to pass motion for a couple of the reasons that we heard. And in discussing the bill with my colleagues following the hearing, I just really became firmly rooted in my idea that regional planning that involves environmental accessibility, bicycle access, and addresses the amount of traffic that would come into that area would precipitate this. And, you know, it's really important to me to check with everybody. And I didn't see testimony today from the Chamber of Commerce or from DNCR. So for those reasons, I'll be voting against the ought to pass. And I just think this is premature and not detailed enough in terms of how it interfaces with the other players involved in the area. Thank you.
Thank you. Anyone else to speak on 241? Seeing none, would you call the roll?
SB 241 ought to pass. Representative Davis.
Yes.
Representative Gould. Representative Donnelly.
Yes.
Clerk votes yes. Representative Bridle.
Yes.
Representative Dupont.
Yes.
Representative Lunny. Representative Taylor. Representative Nab.
No.
Representative Vale.
No.
Representative Baldwin. Representative Darby.
No.
Representative Ryan.
No.
Representative Bucco.
No.
Representative Sargent.
Yes.
And the chair.
Yes.
9-7.
9-7 passes. Will there be a minority report from the 7? Thank you. I close the exec on SB 241 FNA. I then open the exec session on SB 299 relative to penalties for contractors violating water pollution and waste disposal regulations. Believe I have a motion from Representative DuPont. Thank you, and I believe we have a second from Representative Sargent.
Second.
Does the maker wish to speak?
No, it's just a good bill. It protects the homeowner and reins in the bad actors.
Thank you. Will the second wish to speak?
I think this is a great bipartisan bill, and I hope it passes.
Thank you. Anyone else wish to speak on the motion? Seeing none, I ask the clerk to read the roll.
Senate Bill 299 ought to pass. Representative Davis.
Yes.
Representative Gould.
Yes.
Representative Donnelly.
Yes.
Clerk votes yes. Representative Bridle.
Yes.
Representative DuPont.
Yes.
Representative Lunny.
Yes.
Representative Taylor. Representative Nab.
Yes.
Representative Vale.
Yes.
Representative Baldwin. Representative Darby.
Yes.
Representative Ryan.
Yes.
Representative Bucco.
Yes.
Representative Sargent.
Yes.
And the chair.
Yes.
16-0.
Consent? Consent. Close the hearing on SB 299, exec session on SB 110 FN relative to terrain permitting. I believe we have a motion from Representative Donnelly.
Thank you, Mr. Chair. I would like to make a motion for OTP for SB 110 FN.
Thank you. Representative Darby?
Thank you, Mr. Chair. Yes, I'd like to second that motion by Representative Donnelly.
Thank you. We have a motion made and seconded, OTP. Representative Donnelly, do you wish to speak to your motion?
Thank you, Mr. Chair. So this particular bill came from the Senate, but it also had been passed on House Bill HB 2. So at this point, it seems a bit redundant. So I'd like to ensure that it passes here as well, just to ensure this goes through.
Thank you. Representative Darby, do you wish to speak to your second?
Thank you, Mr. Chair. Yes, I'd like to, reaffirm what Representative Donnelly said, and that this should be the strong House position. And by passing this, we can ensure that it's included in HB2. This is an example of, I think, how regulations can be scaled back, but we can still protect the environment, and the government can work for us. And so I think this is a great example of helping to promote housing within the state, housing development within the state.
Thank you. Anyone else wish to speak on this motion? Seeing none, I'll ask the clerk to read the roll.
SB 110 ought to pass. Representative Davis.
Yes.
Representative Gould. Representative Donnelly.
Yes.
Clerk votes yes. Representative Bridle.
Yes.
Representative DuPont.
Yes.
Representative Lunny. Representative Taylor. Representative Nab.
Yes.
Representative Vale.
No.
Representative Baldwin. Representative Darby.
Yes.
Representative Ryan.
Yes.
Representative Bucco.
Yes.
Representative Sargent.
Yes.
And the chair.
Yes.
15-1.
I'll ask the one, consent? You okay with consent? Okay. No minority report, Representative? No. Okay. So SB 110 FN will go on consent. I'll close the exec session on SB 110 FN. Those concludes all the bills we have from the House and all that we got from the Senate. So I'll officially ask you to remain, but I'm going to close the exec session today. And as Christy always reminds me, turn my mic off.